And right now we are going to pass to a more technical topic. We are going to touch on legal and taxes, and we are going to be joined by the founders of VD Law Group, which is a really known figure in the IT and C legal environment. And we'll have Luca, who he's a leader in navigating complex investments and disputes. And his knowledge in fintech and blockchain places his firm at the forefront of the technology. And then we'll have Sergiu, who's been designated as a prestigious Brand 1 lawyer in fintech by Chambers and Partners, which is the most prestigious entity in the legal industry. So let's welcome them with a big round of applause.
Hello everyone, good morning. Happy to see you here in Romania. First of all, congratulations to our legends, Eddie and Octavian Stănescu, because they did an amazing job organizing two big events in the past 2 months here in Romania, ATH Bucharest and NFT Bucharest, which is amazing and huge for our ecosystem, because we have to recognize that we are a small community, a small ecosystem. But hopefully with MiCA, Romania will stay in the same line with all EU countries, starting with January 2025. And from that point, it is our role to raise the bar and do a lot of things in order to compete with all other EU countries, because now we have equal chances with them. So me and my partner Luca will try today to answer to all your questions. If you have any question, please just raise your hand. So if you're a crypto service provider or a crypto enthusiast, don't hesitate to ask anything during the panel or after the panel, because we are here to, let's say, clarify this mystery brought by MiCA. So first of all, I think it's very useful to go very quickly through the steps that you must go through when you organize an ICO or when you launch a token. So basically there are 8 main steps, main points. So we used to assist our clients from scratch. Actually we use to help them to shape the idea. Because when you have an idea, it's better to discuss with a lawyer. So I'm not selling our services, but it's cheaper to discuss with him upfront. When I say upfront, I'm saying it's easier for you to discuss with them before starting to develop something. Because there are some things that you must do in another way in order to achieve the same result and to operate legally. So the first step is we help our clients to shape the idea in order to be able to operate legally. The second step is to review the white paper, which is one of the most important documents for an ICO. Some words may have a different meaning from the legal point of view and from colloquial point of view. There are also, I think, 30 words that you must avoid. If you have those words in your white paper, the white paper can be requalified as a prospectus, an invitation to invest in a security. So there are many things that must be only rephrased. It's easy, but it's extremely important. So first step is to shape the idea. Second step is to review the white paper. The third step is to draft the terms and conditions that must be attached to the white paper when you publish the white paper on your website. Because according to 26 jurisdictions, just publishing the white paper on your website can be qualified as, actually can requalify your white paper as a prospectus, and you will be under many other regulations. And you don't want this. You need to clarify why you are publishing this white paper, and the answer is because you want to sell tokens. You don't want to raise funds for investment purposes. So in order to have a clear idea, there should be no difference between selling shoes and selling tokens, because utility tokens, I mean, because utility tokens could be qualified as products, because with a utility token you should be able to buy a product developed by the issuer or to access a service that is offered by the issuer. So it's kind of the same thing like selling, I don't know, consultancy services or shoes, generally. Shape the idea, review the white paper, draft the terms and conditions that must be attached to the white paper. Fourth step is to draft the SAFT. The SAFT is the agreement that regulates the relationship between the token issuer or the reseller and the first buyer. The fifth step is to draft the terms and condition, the terms of use regarding the token, which is a very important document that regulates the relationship between the token issuer and any subsequent holder of your token, because after the public, the guy who bought your token in seed is able to sell it to a third party, and that third party is able to ask you many things if it's unclear. For example, to buy back or redeem the token, which is not the case because it's not an investment tool, it's a product or access to a service. The sixth step can be done only if you go through the first 5 steps, because the sixth step is related to the legal opinion. We are able to draft the legal opinion only if we have all the previous things done correctly, and we will analyze the entire project, the product, and the token, and we will decide together if the token is a utility token or it's a security token. We all hope to have utility tokens, but sometimes you discover that you have an amazing kid, which is a security token, and you have to be very careful, because creating, selling, or trading security tokens without having the proper license could be a crime in many jurisdictions. So this is the legal journey that you must go through if you launch a token. Sounds complicated, but it's in the same time easy if you respect certain rules. So this is not something new, but it's something that is clear, and we have the same rules within the entire European Union. So MiCA is regulating many things, including token issuers, and the MiCA is also covering all crypto-related service providers. And I will shock you, MiCA is regulating influencers. So crypto influencers must respect MiCA, and my colleague Luca is going to go through all service providers and will tell you a few things about each of them. I mean, if you're a wallet service provider, if you're a cryptocurrency exchange, you need to do specific things, and Luca is going to explain you all that you need to know in order to be interested and contact us later, of course.
Thank you very much. Good morning, everyone. I will start with a brief introduction about MiCA, which stands for Marketing Crypto Assets Regulation, what it covers, and I will kindly ask you to ask us any question you have about MiCA or rumors about MiCA, because it's like you have 10 more minutes of free legal advice, so get the most out of it. So basically, MiCA regulates the following main points. It regulates the crypto assets, which are divided into 3 categories. It's the electronic money tokens, which are the tokens which are backed one-to-one to an official currency. Is the asset reference token, which is a token backed one-to-one to many currencies or any other asset in the world, such as the gold. And we have the utility tokens, and actually the other tokens which are not electronic money tokens and asset reference tokens are considered simply tokens. If a token has utility within an ecosystem, it's considered utility tokens. First point, MiCA does not cover security tokens, so everything that is considered to be a security up to this point will remain outside of MiCA. It's regulated under different regulations. The second most important thing about the crypto assets, NFTs, does not fall within the MiCA regulation as long as they are non-fungible tokens and full stop. If they're non-fungible tokens that have utility within an ecosystem, they might fall under the definition of a utility token and therefore under definition under MiCA regulation. Next one, we have, after the tokens, we have the crypto asset service providers, which are basically a list of around 10 service providers in the crypto industry which need to have a license in order to operate starting from the following year. And here is like a simple, we have the grandfathering period, which basically says that if you're a crypto asset service provider as a wallet provider or crypto exchange or a person which initiates payments in crypto, you are allowed to continue performing your activity without a license until July 2026 if the member states do not shorten this period or waive it at all. And it's very important for all the service...
Unfortunately for us, you're allowed to do this.
Yeah, in Romania it's still okay. Until 30th of June this year, each member state needs to say which is the deadline after which you will need to have a license. So it is very important for crypto asset service provider to have a legal partner around them which can tell them in which jurisdiction you are allowed to still perform your activity without a MiCA license, because it will be very important because each country will have a different deadline. So you have to keep up to date with this one because it's extremely important for everybody.
So, and I have one more thing here to add. Imagine, so you must be active before 31 of December in order to benefit of this buffer transition period. But there are two things that must be added. I'm pretty sure that banks and other service providers or investors will indirectly force you to obtain the license before the end of this buffer because they don't want to be involved in someone that is not fully compliant. At the end of this buffer, there are chances to fail in obtaining the license. So this is the first thing. The market will force you. So that's why you need to be ready in order to obtain the license as soon as possible. And the second thing is you have in mind, just have in mind that you must operate before the end of this year in order to be able to benefit of this buffer. But you must operate with all the features that you want to offer to your clients. I mean, if you have in your roadmap five features that must be regulated, actually that are regulated features, and before the end of the year you only launch 3 of them, there are opinions that will say if you want to start the rest of the features, you are not able to start offering them, even if the company is providing the rest of the features before the end of the year. So I truly suggest you to come to us to discuss your future plans in order to be able to decide together what you are doing and what you should do before the end of this year, because after it's impossible to say or to prove that you were on the market with all your features.
And then there's one more thing I want to add in here. You have also to check each jurisdiction because, for example, Italy says, okay, you are allowed to perform your activity until July 2026 if you have submitted the application for MiCA license by the end of this year. So there is a double condition. So you also have to double check in each jurisdiction before you getting a MiCA license to be sure that in that specific jurisdiction you may not be compliant with a certain local regulation. So it's very important to be up to, until the moment you get a MiCA license, it's very important to be up to date in every jurisdiction you are performing your activities. So we have the tokens, we have the crypto asset service providers, and we have the market abuse. Starting from the end of this year, we have a comprehensive regulation under MiCA about market abuse regulation, which also includes the influencers. So there is some sort of new rules in order to avoid the pumps and dumps and unfair marketing, in order to avoid what is actually happening nowadays in the capital markets industry. They're also implemented in the MiCA regulation, so it won't be a market where everybody can come up and say whatever they want because there are no consequences. And the fines are huge, I can say, are huge, up to tens of millions of euros in this case.
And imagine that sometimes influencers or different small service providers are doing great things or are involved with projects with a huge impact, but they are involved as a natural person. without having a legal company between them and the market, and they're personally liable for covering the damages, if any.
And it's one interesting fact, the difference between the market abuse regulation in the securities market and then in crypto. For example, when you're having an IPO in the classic industry, there's a list you have to submit to the financial authority with the persons that have access to the sensitive information in order for the financial authority to see if someone has leaked information to benefit on himself. MiCA does not require this thing, but there's a pluses and minuses in here, because if a financial authority might say that you had access to sensitive information before an ICO, let's say, and you have influenced the market by using that information, you can be fined, and also you can have criminal charges in this respect.
Hopefully, at this moment, there are no interdictions regarding the assets that we are able to hold. So even if we are service providers in the industry, we are able to hold crypto assets, which is kind of different from traditional financial market, where you have to stay out of the company to which you provide different services. And another important thing after MiCA is that you must be aware that your service providers are MiCA compliant. So you have to check, if you're an exchange, the tokens that are listed on your platform. If you are a wallet, you must check your users, you must check the service provider that offers you custodial services and so on. So you must be aware that you are MiCA compliant and your service providers are MiCA compliant in their jurisdiction and in the jurisdiction in which you are going to operate. So this is another complex things that must be addressed, and you have to check each of them. Okay.
Maybe if we...
Yeah.
If you... Yes. Meaning what? For what?
For example, all the companies that are not regulated right now, or they are not compliant with MiCA regulations, will they be fined, shut down, closed when it's going to be MiCA in full effect?
They have the grandfathering period. So if you're a service provider, the regulation says that you have, and you're providing services right now, you have until July 2026 to get a license. But each jurisdiction, each specific jurisdiction might shorten this period. For example, Romania may come up and say, if you don't have a MiCA license until 1st of January next year, you're not allowed to continue.
So what will happen to the companies that do not comply with MiCA?
They will be fined. There are yes, they have, at a certain point, it may also be a criminal offense. The fines are huge. The fines are extremely huge. So I think no service provider would dare to perform the activity without a license.
To directly answer to your question, in Romania, for example, and in many other countries, it's a crime to operate a regulated activity without having the proper license. It's a general thing. Secondly, to directly answer to your question, there will be no directly retroactive effects, but the authority who will issue the license, for example, any authority who will issue the license in Europe will analyze what, I am sure that they will analyze what the project did before. So I do not recommend to say, okay, we can do whatever we want until the end of the year, like riding horses rodeo, okay, and after the 1st of January we will apply as a compliant company to obtain that regulation, because they are checking each company and how they act before, indirectly. So this can affect your process of obtaining a license.
It will be very easy for the token issuers, which have issued utility tokens, but because all they have to do is to draft a white paper in accordance with the MiCA regulation. But with the crypto asset service providers, they need to comply with a lot of regulation. So basically, if they will fail to do so, there will be fines and also criminal charges as well.
We have another question there.
What will happen with decentralized protocols? That they don't have founders, they don't have anything, there's just a code on the internet.
There's a recital in the beginning, and this is just the only mention about DeFi in the MiCA regulation. There's a recital in the MiCA regulation which states it's the recital, it's not an article in the regulation. It says, this regulation shall not apply to fully decentralized entities. Full stop.
But DAO, from the legal point of view, DAO, it's only a technical thing. From the legal point of view, DAO doesn't exist. You know, give me your papers, doesn't exist. You have a joke here in Romania. So it's important to know that you can say, I've just published the smart contract, I'm not liable, it's autonomous, so I'm not liable. You are liable because you deployed it. So if you created something that enables others, to launder funds, you are liable for what they are doing. So even if you deploy a decentralized app, you are liable for the actions of that app, how that app can be used, or how, and it's also important because in most of the cases you receive benefits from that app. So just publishing it doesn't mean that it's completely out of view. Imagine that a coffee machine, it's a smart contract, is the first smart contract. It's the coffee machine is a smart contract, and you have to pay taxes. You have to be sure that the coffee and the milk are good and okay and so on. So it's not autonomous. Okay. From my point of view, the difference between, from the legal point of view, the difference between an NFT and a fungible token is only a technical thing. So if NFTs are out of any regulation if there are only pictures, only art. If the NFT is backed by any kind of utility, at that moment it's a difference between them and fungible tokens, only from the technical point of view. You must respect the regulation applicable to utility tokens. It's only a technical thing that you deployed it as NFT and you are able to identify each piece of each token, I mean. So if the NFT is backed by utilities, you have to respect, it can be a utility NFT or it could be a security NFT. And you will have the same problems and you have the same responsibilities. And this will be for sure clarified by ESMA through all the guidelines that they are going to issue in the next year.
Do we have any kind of regulation in Romania, Europe, Romania/Europe, to allow us to hold, for example, Bitcoin on a company's balance sheet?
There is no problem in holding any kind of crypto asset on your company, but you have to have in mind two things. If you buy Bitcoin or any kind of crypto asset, this doesn't mean that you can avoid paying taxes. For example, if I have revenue so actually investments are not expenses. So if you have profit, 1 million profit, if you buy Bitcoin for $500,000, you'll pay taxes to 1 million, because buying Bitcoin is like buying euros. You have, or investments are not exempt.
No, of course, it's not about taxes, just if I'm allowed legally to hold Bitcoin.
Yes. You're allowed to hold, you're allowed to receive Bitcoin in exchange of your service that you provide. So you are able to do a lot of things, but you must respect the local regulation. I mean, the invoice should be issued in lei if you issue the invoice to a Romanian tax resident, or the invoice could be issued in any other currency if you issue the invoice to a foreign entity or foreign person.
What happens if I have an NFT that is composable? So I issue the NFT as like pictures, but then the community comes on top of it and adds, let's say, other utilities.
The regulation is applicable to the issuer. So basically the issuer has the obligation to, in case of utility tokens, you just need to draft a white paper in accordance with MiCA.
You just opened many doors in his mind. So you can't issue, and this must be real, you can't issue the token on a company and with another company to come and say, I put 10 utilities on this NFT.
The issuer has the obligations under
At the end of the day, the one who is offering, so for example, it's a good example. So let's take this example. You are, Luca is issuing an NFT, okay? A collection of NFTs. And you will come with your project and say, okay, if you have those NFTs, you will have those benefits in my company. So at that point of view, you kind of, you adopted the collection and you have to respect all the things as a issuer, because you put those utilities on that NFT. This is not clearly stated, but you act at that point, you act as an issuer because you created the utilities. The regulation is not regarding the technical thing, it's regarding the effect of those technical things. So in my opinion, you act as an issuer, so you should comply with all the regulations. And in this case, I think he's liable. He's liable, and he can have a lot of problems if Luca technically is able to change something on this collection. So it's very risky because you'll be liable, and he's able to, let's say, I don't know, convert the utility token in a security token.
So because the issuer basically
Is the owner of the smart contract.
wrote the smart contract and allowed people to build different utilities on top of it. So he made a conscious decision when he created the...
Sometimes it's unconscious, but the effects are the same. Sometimes, yes. Okay, I think we are out of time. More than happy to answer to all your questions after the panel. Thank you very much.
Thank you.